So what are your options in court after being charged for drink driving? You may either plead guilty or not guilty in court to a charge of drink driving. If pleading guilty in court, the court will proceed to sentence. This means the court will impose a penalty on you after hearing further evidence that you wish to produce. The lightest possible sentence or penalty that can be imposed is a Section 10 or conditional lease order non-conviction, which means you walk away without a licence disqualification and without a criminal conviction on your record. If you need more time to prepare or you need legal advice, you can ask the court to adjourn your sentence to be heard on another day. Your sentence will be automatically reduced by 25% if you plead guilty on the first court date. You can actually significantly improve your drink driving sentence by preparing good character letters. These letters may outline your need for a licence and job and family dependents, including your personal circumstances. If pleading not guilty in court, your case will eventually get adjourned to another day for hearing. The police will then serve you with all of their evidence beforehand. On the hearing, the court will determine whether you're either guilty or not guilty, but only after hearing the evidence from both sides. If you're found not guilty, your charge will get dismissed, putting an end to the case. Now, in some cases, the court may order the police to pay your legal fees. If you're found guilty in court, you'll be sentenced by the court usually on the same day. So what is drink driving? It's a crime to drink and drive in New South Wales. Drink driving is when a person drives a motor vehicle above the threshold blood alcohol concentration limit, known as BAC. The BAC limit for high-range drink driving is 0.15 grams or more, for mid-range it's 0.08 grams or more but less than 0.15 grams, for low-range it's 0.05 grams or more but less than 0.08 grams. Now, drink driving also includes driving under the influence of alcohol, also known as DUI. A BAC reading isn't required to prove a DUI charge. A person can be guilty of DUI simply if the police can prove he or she was affected by alcohol to any degree, even if the slightest. Can you get a Section 10 non-conviction sentence for drink driving? You can plead guilty to drink driving and still avoid a licence disqualification and criminal conviction in New South Wales if the court is convinced enough to order a non-conviction penalty being either a Section 10 1A dismissal or a conditional release order non-conviction. So what's the penalties, disqualification and jail time for drink driving in New South Wales? The penalties for drink driving depend on the BAC level and whether it's your first or second offence. A drink driving offence will be considered a second or subsequent offence if you've been convicted of a major offence, including drink driving, within the last 5 years from the date that you're convicted by the court for your current drink driving offence. Otherwise, it's considered a first offence. The mandatory interlock device program applies to high-range, mid-range and DUI offences. It also applies to second or subsequent offenders of low-range, novice or special range drink driving. The mandatory interlock program requires a convicted drink driving offender to install and maintain an interlock device into the vehicle he or she drives for a certain period of time. Now, the vehicle won't start unless the device returns a zero alcohol reading after blowing into it. For an outline of all penalties for drink driving offences, browse through the table of drink driving penalties on our drink driving page. So how can you get a drink driving charge dropped, or how can you beat a drink driving charge? Now, this can occur if one or any one of the following drink driving defences apply. The at-home defence, if police conduct a breath test on your private property, which includes your driveway. The 2-hour defence, if police conduct a breath analysis or test on you 2 hours after you last drove. The mistake of fact defence, if you honestly believe, based on reasonable grounds, that you weren't intoxicated. The not in motion defence, if the vehicle was not in motion at the time and you weren't trying to put it in motion at the time. And the pharmacologist defence, if a pharmacologist report can be obtained stating that you were below the threshold drink driving BAC limit at the time of driving. Now, if any such defences apply, an experienced drink driving lawyer can negotiate with the police to try to get the charge withdrawn earlier, saving legal fees and stresses of going to court. For tailored advice and representation in court for drink driving, call our 24/7 hotline to arrange a free consultation today. Thanks for watching.